Hello and welcome to Win Without Law School. I am Arizona lawyer Julie Lebenz. Today we are talking about required disclosure in a modification or enforcement case. So this is post-decree or post-order, and we're looking at what are your disclosure requirements in this type of case. So first we're going to talk about what is disclosure. And then if you have a modification or enforcement case involving legal decision-making and parenting time, we'll talk about the required disclosure for those cases. If you're dealing with a modification and or enforcement case for child support and or spousal maintenance, we'll talk about the required disclosure for that. And then we'll talk about what you need to disclose regarding witnesses and additional exhibits, and then we'll move into a summary. So what is disclosure? Disclosure under Rule 91, which has to do with when you're post-decree or post-order, it indicates that each party must comply with Rule 49, which is the standard disclosure rule under the Arizona Rules of Family Law Procedure. And you're supposed to comply with Rule 49 within the time established by the court at the conference or hearing or as agreed by the parties. So what is disclosure? Generally, disclosure is intended to ensure that each party is fairly informed of the facts, data, legal theories, witnesses, documents, and other information that is relevant to the case. A party must disclose information in the party's possession and control, as well as information that the party can determine or acquire by reasonable inquiry and investigation. And for good cause, the court can limit disclosure. Now, under Rule 49, disclosure is due 40 days after the filing of the first responsive pleading to a petition. However, when you're post-decree, there's no required response. And so that's why we have under Rule 91, when you're post-decree, the time for your disclosure is as ordered by the court or agreed to at the parties, or agreed to by the parties. So the parties will generally get together with the court at a resolution management conference, and at that point, that's when the court can make orders about disclosure. But really what you'll need to be cognizant of is that in this post-decree, post-order realm, you'll need to be looking at the court orders to see when your disclosure is due. And keep in mind, you can always be proactive and get your disclosure out there. You don't have to wait for the deadline in order to exchange your disclosure. Also be aware that once you do your initial disclosure, you have an ongoing duty of disclosure in which you should serve an additional or amended disclosure if you obtain new or additional information. Also, if you obtain new or additional information, you should disclose that within 30 days of discovering it. And if your case is already set for trial, you should disclose the new information as soon as possible. So are you requesting to modify or enforce legal decision-making and or parenting time? If so, this is the required disclosure that you will need to engage in for your case. Number one, if there have been any past or current protective orders between involving you or a member of your household, then you need to disclose the protective order and the underlying petition. If you or your co-parent, if you're aware of this, if either of you have undergone any treatment in the past 5 years for psychiatric or psychological issues, anger management, substance abuse, or domestic violence, then you need to include the name and address of each treatment provider and the period of treatment. If in the last 10 years, you or any member of your household, or if the opposing party or any member of their household has been charged with a crime or convicted, they need to disclose the date, description, location, and documentation regarding the charge or conviction. If there have been any Department of Child Safety investigations involving you or a member of your household within the last 10 years, you need to provide the date, description, location, and documentation of that Department of Child Safety investigation. Are you requesting to modify or enforce child support and or spousal maintenance? Let's look at the required disclosure for child support and spousal maintenance. This also comes up if either party is requesting an award of legal fees. Each party needs to complete an affidavit of financial information. And then you need to provide proof of income from all sources. So tax returns and related tax documents from the past 3 years, information about all sources of income, proof of court-ordered child support and spousal maintenance actually being paid in any other case, proof of medical insurance coverage for the child involved in the case, proof of childcare expenses, proof of expenses paid for private or special schools or other particular educational needs, and proof of any expenses paid for special needs or gifted children in common to the parties. So this is additional disclosure if your case is involving child support, legal fees, spousal maintenance. So here's this the rule about spousal maintenance, and you'll notice here it's the completed AFI, and then they want you to complete or to exchange all of the documents and information described in E2, which E2 is what we just went over, the proof of all income, proof of all sources of income and all of this information. So the disclosure requirements are the same if your case involves child support, spousal maintenance, and or legal fees. Let's look at required disclosure for witnesses and exhibits. Each party must disclose the names, addresses, and telephone numbers of any witness who you expect to call at trial, along with a statement fairly describing the substance of each witness's expected testimony. The court may not allow a party to call a witness if you didn't disclose the witness at least 60 days before trial. If you have an expert witness, you need to disclose even more information, their name, address, and phone number, but then also the subject matter that they're going to testify about, the substance of the facts and opinions they're going to testify about, a summary of the grounds for each opinion, their qualifications, and the name and address of any custodian of reports the expert prepared. And there's a 60-day disclosure deadline for expert witnesses, 60 days before trial. So for each type of witness, whether it's a regular witness or an expert witness, you need to disclose their contact information, and you need to disclose a summary of what they're going to testify about. And then for the expert, you also need to show their qualifications, any reports they've made about the case, the substance of what they're going to talk about. So, and you need to do that at least 60 days before trial or by any other deadline ordered by the court. For exhibits, if you have documents, audio recordings, or videos not listed in your disclosure that you want to use at the hearing and or trial in your case, then you must disclose each document, audio recording, and video you intend to use in your initial disclosure or in a supplemental disclosure statement. So we went through the categories of disclosure under Rule 49 regarding the mandatory disclosure for legal decision-making, parenting time, child support, spousal maintenance, legal fees. But let's say you have other documents that are just relevant to your case. You want to disclose those as well. So that's where you can attach those as additional exhibits, list them in your disclosure statement and then attach them and provide copies to the other side in your disclosure statement. Disclosure statements are not filed with the court. Instead, they are exchanged between the parties. And when we talk about served, that generally means mailing a copy to your co-parent or your opposing party. Now, disclosure statements can get really long. They can sometimes be hundreds of pages if you're attaching tax documents and all of your exhibits you want to use, and criminal histories and counseling records. There can be really long disclosures. So you can reach out to the other side and ask if they'd like an e-copy. And if they agree, then you can send them an e-copy of your disclosure. If they don't agree and they want a hard copy, then by the rules, you are required to provide them with a hard copy. Let's look at the set form in Maricopa County for the disclosure statement. So you're going to fill out the caption, each party's name, your contact information, the case number, indicate which party you are, down here. And then you'll see for legal decision making, this is all the required disclosure that we just went over. And if any of this applies in your case, you'll attach a document that's called Exhibit A, and then attach these documents behind it. For child support, we went over everything that's required. Attach a document labeled Exhibit B and attach all of these records. If spousal maintenance and attorney's fees are at issue in your case, Exhibit C. Now, if you have child support, spousal maintenance, and/or attorney's fees, you obviously can have all of these records as one exhibit. But if you want to delineate between the two requests, you can do an Exhibit B for child support documents and Exhibit C for the spousal maintenance and attorney's fees documents. Property should not be at issue in a post-decree case. This is more tailored towards divorce, so that's not going to apply. Debts, although it's not referenced here, this is referencing debts in a divorce context. If you're looking to enforce certain parts of your decree about non-payment of uncovered medical expenses for your children or uncovered extracurricular expenses, if that was something agreed to in your decree, or unpaid child support, unpaid spousal maintenance, you could attach those documents as Exhibit E regarding debts and label here what you're attaching, cross this out, and write in what you are attaching. That would be an option. Witnesses are going to be Exhibit F, and I'll show you the step forms for that. Expert witnesses are G. If you have any other exhibits, I would write in I and put an arrow down here, or C attached, and list out the exhibits that you're also enclosing. And then keep in mind you do have this continuing duty to disclose. So if you come across additional documents you want to use or new evidence comes out, you need to disclose it. Here's the set form to disclose witnesses, so their contact information and a summary of their expected testimony. It gives you some room to list a few witnesses. You may only have one. You could list yourself if you are going to testify. That would be a good idea. You may want to call the opposing party as a witness. You can list them and list what you're going to ask them questions about. And then any other witnesses you would list. And then here's Exhibit G if you do happen to have any expert witnesses. And look back at the rule and list out all of the required information you need to disclose for an expert witness. Here's the mailing certificate, so just fill this out and then follow it. And the disclosure statement does not get filed with the court, so that keep a copy for your records and then mail a copy or email to the other side if they agree. Also, part of the disclosure requirements are to file a proposed resolution statement. So under Rule 49, it's due 30 days after exchanging the initial disclosure statement or is otherwise ordered by the court. Keep in mind that if the court sets a resolution management conference, they'll want you to file a resolution management statement 3 to 5 days prior. So really keep an eye on your court orders to see when your resolution management statement is due. And it's called the proposed resolution statement. I just called it a resolution management statement, but to see when your proposed resolution statement is due. So fill this out, indicate what party you are, indicate if you have a 4D case, children at issue in your case. And then this document is really tailored for divorce and custody cases. So you're going to need to edit this to fit your case because you're in a post-decree situation. So if you're looking to modify custody, you can indicate down here what your requested changes are. If you're looking to modify child support, you can indicate what you want child support to be. Spousal maintenance, you can put any information there. Information about property is not going to apply for modification or enforcement. Well, I mean, it could apply for enforcement, but it's not going to apply for modification. But this likely is not going to help you for the enforcement section. So instead, you can skip these parts and you could write in here what your requested outcome is, because this is your proposed resolution. So identifying what's at issue in the petition, and then listing here how you want the court to resolve the disputed issues. Just as a reminder, if you've got child support, spousal maintenance, and/or legal fees at issue in your post-decree case, you're going to need to submit an affidavit of financial information and proof of income from all sources. So let's look at the affidavit of financial information form. Just fill this out to the best of your ability. You really want it to be accurate. This is going to be information about your employment and your income. If you have your own business, this is where you put in information about your business. And then for item 6, if your case is involving child support, you would fill out part 6. And then for part 7 and 8, if your case involves spousal maintenance, attorney's fees, a change in child support or enforcement, then you're also going to fill out 7 and 8. And then here's the final mailing certificate. So fill that out accurately and follow it. The AFI does get filed with the court, and a copy gets mailed to the other side. So just a reminder, if you have a case involving child support, spousal maintenance, or a request for legal fees, there's a lot of documentation to disclose. So your AFI, and then proof of income from all sources. And that includes tax returns for the last 3 years. All right, we've come to our summary. Remember, for time for disclosure, the general rule is 40 days after filing a response, but in the post-decree context, a response is optional. So the time for disclosure is likely going to be set by the court or agreed to by the parties. So watch your court orders, listen to what happens in court. A disclosure deadline will likely come out. If you do your initial disclosure, but then you have additional information or new information that comes out that you want to disclose, then you need to do a supplemental disclosure statement. And you need to disclose your supplemental or additional information within 30 days of discovering it, or if your case is already set for trial, then as soon as possible. So remember, for legal decision-making and parenting time, you have certain disclosure requirements. For child support, legal fees, spousal maintenance, there's certain disclosure requirements, and then witnesses and exhibits, and then you've got that proposed resolution statement. So a lot of different documents to file, but of course, or not to file, but to disclose. And of course, not every document or issue will apply in your case. So be really cognizant of what's at issue in your case and what your disclosure requirements are. So for legal decision-making, if that's at issue, or parenting time, then are there any protective orders? Has there been any periods of psychiatric or psychological treatment, anger management, substance abuse, domestic violence? Have there been any criminal charges or convictions involving either parties or members of households? Any Department of Child Safety investigations? So if any of those things have happened in your case, then you need to comply with these disclosure requirements. Got to do that AFI. If you've already filed one in your case, then that's done. But if it needs to be updated, if your income or expenses have changed in the meantime, this would be a good time to update your AFI and file that with the court. And then all of your tax records for the last 3 years, proof of income from all sources. If you're paying child support or spousal maintenance in another case, proof of that. If you're providing medical insurance for the child in common to this particular case, you want to provide proof of that. If you're paying child care expenses for the child at issue in the case, proof of that. Private or special schools or particular education expenses, as well as any special needs or gifted expenses, as well as expenses related to a child in common with a disability. So proof of all of that, if that's an issue in your case. For witnesses, you got to have their contact information and a summary of what they're going to testify about. And then for expert witnesses, their contact information and additional information about what they're going to testify about. You need to disclose witnesses and expert witnesses at least 60 days before trial or by whatever deadlines is set by the court. In addition to the required disclosure for legal decision-making, parenting time, child support, spousal maintenance, and legal fees, if you have other types of exhibits you want to use, then you must disclose those as well, either in your initial disclosure or a supplemental disclosure. And then the resolution statement is going to be due at some point. The SEP form is not the best for post-decree matters, so you'll need to tailor it. You can potentially type up a similar form on your own that is more tailored to your case. But the bottom line is, in a resolution statement, you're looking to tell the judge and the other side how you want the case to be resolved. What is your proposed resolution to resolve the case? All right, that brings us to the end of today's presentation. Thank you so much. If you have any questions, please bring those into the Q&A.